Hey everyone, I'm Val Chenko, General Counsel and Chief Privacy Officer at TrustArc, and I'm here to answer the question of what is the best way to mitigate risk with cross-border data transfers. So, first off, to set the record straight, not every country, state, or region actually has restrictions, but you'll certainly hear about some of the common ones like the EU, UK, Switzerland, and China, but there are many. Below, I'm going to highlight a few general overviews and thoughts around cross-border transfers, just to give you some directions on how to mitigate the risk. Places like the EU have adopted a concept called adequacy, where you can transfer data from the EU to certain other countries without additional requirements. Basically, those countries have safeguards in place with their own laws that are similar enough that you're allowed to transfer data while it's sufficiently protected by law. Sometimes to take advantage of adequacy, like in the US, you do have to take some extra steps. There is this framework called the Data Privacy Framework where you can enjoy transfers between the US to EU, US to Switzerland, or US to UK. You will need to sign up for that framework called the Data Privacy Framework, as I mentioned, or DPF, run through the International Trade Administration, US Department of Commerce. And of course, as always, TrustArc can help you with that process. We can help you validate, and we can give you that shiny seal if you can pass the assessment. Additionally, there are standard contractual clauses. A number of regions, including the EU, UK, Switzerland, and China that I mentioned earlier, have adopted this premise of these sets of terms and conditions that have been approved by the regulator or the Data Protection Authority that, for example, a vendor and their client can sign. These terms typically have certain fixed obligations that you can't negotiate. So you really should check and review and make sure you can actually adhere to these before you actually start to use them. Additionally, companies like TrustArc can help you assess whether you meet those measures through things like our GDPR assessments. One other way is permission. In some cases, like a one-off and not continuous transfer, think in email more so than a SaaS application. Consent from an individual is enough to transfer their data. Under GDPR's Article 49, for example, if you ask permission to send data from one point to another on an ad hoc basis, you might be able to do it without, something more. There are other mechanisms that you might hear about a little bit less that are maybe for some more sophisticated parties, such as binding corporate rules in the EU or the APEC cross-border privacy rules and privacy recognition for processor frameworks in the Asia Pacific. TrustArc can also assist with the APEC framework, but these are some other ways that you can transfer data without additional safeguards. Other things that you can and should do to mitigate risk, which might be common sense but you should think about, are be transparent and clear. Don't hide or bury the fact that you might be transferring data. Disclose the receiving parties and where they might be. The ways that you do that will vary, but some common places you might be doing that are a privacy policy, a commercial agreement, a data processing addendum. For a certain category of providers, a sub-processor disclosure like a SaaS vendor. Additionally, you might need to conduct a risk assessment. For example, some laws do require you to assess risk on a basically country-by-country basis for the transfer. You'll have to look at what countries you're sending the data to and the likelihood that the government authorities of that country will actually look at that data. Some laws that typically include additional transfer risk assessment requirements are China, the EU, the UK, Switzerland, as well as the Quebec province of Canada.